This is a test. This is a test. This is a test of the ceremonial courtroom, making sure everything is good on the line.
15 seconds. Okay.
Okay.
All right.
All right.
And then
And
we're
then
gonna,
we're gonna,
once
once
after
after
the
the
tape,
tape,
we're
we're
going
going
into
into
a
a
break.
break.
We turn
We
it
turn
on.
it on.
That left
That
hand
left
side
hand
there.
side there.
The Honorable Judges of the United States Court of Appeals, moving forward the 7th Judicial Circuit. Hear ye, hear ye, hear ye. All persons having business before this honorable court are admonished to draw near, give their attention, that the court is now sitting. God save the United States and this honorable court.
Good morning, everybody. We're here today for oral argument. We're going to begin by calling appeal number 24-2947, Johnny Savory versus Alen Andrews et al. And we'll begin with oral argument. Mr. Sotos, from you.
Thank you, Your Honor. Counsel, may it please the court, good morning. This up a little bit. My name is Tom Sotos. I represent the defendant's appellants in this matter. I would like to reserve 5 minutes for rebuttal. Thank you. Today, we are asking the court to reverse the lower court's denial of summary judgment on 4 of plaintiff's claims, specifically the denial of absolute immunity on plaintiff's fabricated confession claim stemming from his 1977 criminal trial, and the denials of qualified immunity on plaintiff's claims for destruction of evidence, coerced confession, and unlawful detention.
Why don't you begin with appellate jurisdiction?
Yeah, absolutely. So luckily, that's what I've got written down here, Judge. The bulk of plaintiff's brief, as you know, is not about the merits, it's about jurisdiction. I think the majority of this argument can be cut through with some expediency if you just look at the actual defenses to the claims themselves. It's our position that specifically 3 of the immunity defenses on appeal quite clearly arise out of exclusively undisputed facts, and those are very easy claims to resolve jurisdictionally. Those are the immunity defenses to the destruction and fabrication claims, which have extremely narrow factual predicates. Those are undisputed factual predicates. And then there's the coerced confession claim. That claim requires us to accept all of plaintiff's allegations about his interrogation tactics. He was present for his interrogation. So all of the facts that we have brought up on appeal, we are accepting his version of events. Our immunity defense simply asks whether those tactics violated clearly established law in 1977. As we see it, the only superficial factual issue, and I emphasize superficial, comes from our qualified immunity defense to the unlawful detention claim, and specifically to our contention that 6 witness statements contribute to arguable probable cause. Plaintiff claims, and the lower court did find, that because plaintiff alleges that the 6 witnesses' statements to officers must have been fabricated, he is entitled to that inference, even though his only evidence for that allegation is his denial that he made inculpatory statements to the witnesses in the first instance. But that lower court finding, that does not arise out of a dispute of fact. We accept, and we have always accepted for summary judgment purposes, that plaintiff has denied making inculpatory statements to the witnesses. And we accept that in plaintiff's version of events, the officers, based on that denial, he's entitled to the inference that the officers fabricated those witness statements. But the granting plaintiff that inference at the summary judgment stage, that defies probable cause law. It's a very narrow legal issue. It does not actually arise out of a dispute in evidence. The key case here is Coleman versus City of Peoria. That's a 2019 case. This is talked about in our brief. There, this court doubled down on a long line of cases holding that absent evidence showing that officers at the time of their investigation have reason to doubt the reliability of third-party witness statements, officers are entitled to rely on those witnesses' statements for probable cause in the face of a suspect's denials.
But isn't the argument here, though, a little bit different? At least the way I saw it, Coleman is not an interlocutory appeal, I think, Coleman. But isn't the question here, the way at least I see the plaintiff's argument, is that he's alleging that the police officers knew at the time they were determining probable cause that the witnesses' statements were fabricated, which distinguishes this case from Coleman, I think, or the argument that you just made.
I appreciate and agree with the distinction about the procedural posture of the case. In addition, what you said about the allegation is true. Plaintiff is alleging that, but summary judgment law, federal rules of evidence, and the law governing probable cause are exceedingly clear on this. An allegation alone is insufficient to defeat summary judgment, regardless of the circumstances.
Even when the district court, though, found that there was a dispute of fact?
We believe that there are 2 ways for the court to address this. We believe because the court's finding on that issue arises out of a clear error of probable cause law, that is an abstract issue of law this court can adjudicate solely based on the law itself. The granting of Savory, the granting of plaintiff the inference on the unlawful detention claim about the 6 witness statements comes from a misunderstanding of the way that officers are entitled to rely on information they receive at the time for probable cause purposes. The only evidence in this case of any, I hesitate to call it doubt, but granting plaintiff those kinds of inferences, unreliability of a witness statement, doubt of a witness statement. The only actual evidence of that comes from 1981, 4 years after the investigations. The only basis to find any sort of disputed fact or an inference or to withhold these statements from the police officer's purview in the probable cause context is to simply permit plaintiff to say that the officers fabricated the statement. That is speculation. And the district court held this in the context of the 1981 fabricated evidence claim.
But my question though is, once the district court says that there's a dispute of material fact on that issue, what's our jurisdiction to review that?
Our first answer would be that you can step in because it's an abstract issue of law on the probable cause. The error comes from the law. It comes from probable cause law. However, accepting the premise that this is a disputed fact.
Why can't we fix that? Okay, so you're saying there's an error the way the district court determined the way probable cause is analyzed. Why can't we fix that? What does that have to do with the district court's determination that there was a dispute of material fact on that issue?
Well, in Manry versus Lee, in a number of cases, the court has held if we accept plaintiff's version of the facts, even allowing for a lower court finding of disputed fact, this court can address the abstract issues. And my representation here is that we are accepting that Savory is saying what he's saying. What our argument is one step past.
But don't you have to accept, though, if you're going to accept that, don't you have to accept that the witnesses' statements were fabricated and that the police officers knew it in 1977? Hold on one second.
Absolutely.
You accept the fact that the police officers' statements were fabricated. I'm sorry, the witnesses' statements were fabricated. The police knew it in 1977. But then you argue that there's still probable cause even throwing out the witnesses' statements.
Mm-hmm. Yeah, I understand the proposition. In the interest of time, we do not believe that we have to accept that there is a disputed fact about whether the statements themselves were fabricated in 1977 because there was no evidence to back that up. And the finding of disputed fact arose out of a misapplication of probable.
What's your best case? What's your best case to support that argument for interlocutory jurisdiction?
That argument flows from the theory that this court has jurisdiction to address abstract issues of law at the interlocutory stage. We do not have a specific case addressing this. However, granting the proposition that there was a finding of disputed fact by the lower court, which theoretically should impede interlocutory jurisdiction, accepting that as the premise. And I understand the district court did find that here. In Johnson versus Jones, the case that kind of sets the groundwork for all of these interlocutory appeals, the Supreme Court specifically anticipated instances where district court findings of fact would be insufficient and the Seventh Circuit and any other circuit would have to take on a greater burden. It did not say it would happen frequently, but it said it would have to happen. Now the Supreme Court said in Johnson versus Jones that the instance they anticipated was where a district court failed to give the court findings of fact that they could use for the interlocutory appeal. So the Court of Appeals would have to go down and make their own findings of fact. However, since Johnson versus Jones, a number of circuits have taken that holding. They've also looked at Scott versus Harris, and they have found that where a district court's findings of fact are inadequate. This language in particular comes from Taffy versus Wenger. This is 11th Circuit's a federal appendix opinion, but it uses a surfeit of 11th Circuit case law to find this. Where a district court's findings of fact are inadequate, Johnson versus Jones permits the courts of appeals to go in and take their own look at the facts to make sure that there are genuine disputes. In Jeffers versus Gomez, this is a 9th Circuit case, the 9th Circuit specifically found that district court findings of fact that are based on findings of disputed fact that are based on allegations as opposed to genuine evidence are insufficient to deny jurisdiction for an interlocutory appeal. We would direct the court to those cases. We would suggest that if the court were to go the other way, there is a risk of inter-circuit split on that issue. I would remind the court again, we believe that the court can address this issue narrowly and clearly as a matter of arguable probable cause and probable cause law, because the error arose as a matter of law. The district court misapplied U.S. versus Williams. It failed to observe Coleman versus City of Peoria and its progeny. That's Graminos, that's Reynolds. And the error flows from that. However, if the court wants to wade into the facts, we believe the court has the jurisdiction to do that. Johnson versus Jones allows that. It specifically says the court can do that in specific instances. Beyond that, Briefly, to try to tie up the jurisdictional issue, the absolute immunity defense, the fabricated confession claim, there's one fact there, it's undisputed. The allegedly fabricated confession was only introduced at the 1977 trial by officer testimony. That is undisputed. It's the only fact giving rise to that defense. Jurisdiction is clear.
Was it introduced in the second trial?
It was we did not raise the defense with the second trial because there are some lower court decisions that suggest where the police report is used, absolute immunity is not available. The police report in the second trial, 1981, it was used for fresh recollection. It was referenced. In the 1977 trial, it played no role. That's why we raised it there. For the destruction of evidence claim, again, very narrow factual predicate. We accept that the evidence was destroyed in 1977. That's the only evidence, that's the only time in the record where the evidence goes missing. We accept that the officers implicated did it. And the parties agree DNA testing did not exist for quite some time. Those are undisputed facts. On the coerced confession claim, again, we have to accept all
Where
of the facts.
in the record are you getting that the evidence was destroyed in 1977?
I appreciate the question, Judge Jackson. This has been somewhat difficult for defendants to adduce this. It is the only, we argued in the lower court that there is no evidence of destruction in and of itself. The lower court rejected that merits finding. We remain a little bit unclear why. The only evidence in the record of the evidence going missing, and the last time it was in contact with any of the Peoria Police Department officers, is 1977. There are two police reports from September of 1997. I can get the the docket sites for you that mention Cannon and Jackowski in the context of destruction. And then at trial, I believe it was Jackowski, it might have been non-defendant Gunsowski, who mentioned that the cutout wasn't around anymore and they couldn't find the hair.
The 77.
That was in 1977. After 1977, there's no tethering of the officers to the evidence. There's any allegation of destruction post 1977 is purely an allegation. There's no evidence of that. I would like to reserve the remainder of my time, if I may.
Very good. Thank you, Mr. Sokos.
Thank you, Your Honor.
Ms. Pierce, we'll move to you.
A little lower.
You should be able to lower. Derek can help you.
A little bit shorter than my opposing counsel.
In my last argument in this court before I became a judge, I hit the button, it went down. The person who had to argue after me was very upset with me.
Don't do that to me.
All right.
They have a disabled judge.
Oh, sorry. Okay.
All right.
Ms. Pierce.
Good morning, Your Honors.
Morning.
May it please the court. Defendants misrepresent the law in this jurisdiction and from the Supreme Court about when the court has jurisdiction over an interlocutory appeal. This circuit has been clear that this court may not consider the district court's determinations about sufficiency of the evidence. And this court has been clear that the defendants must take all evidence in Mr. Savory's favor on interlocutory appeal. They have to argue that this is a legal question because their whole appeal is challenging the facts that the district court found on summary judgment.
Ms. Pierce, can I ask you a question regarding that, the appellate jurisdiction issue? If the district court, take the fabrication of the witnesses' statements, if the district court, the defendants offer the witnesses' statements and say in 1977, based on the witnesses' statements, there was the police had at least arguable probable cause. And the plaintiff's only response to that is, I deny that fact, and I submit that the statements were fabricated. And there's no evidence whatsoever to support the argument or the position that the statements were fabricated. If the district court was determining that at summary judgment, usually the district court would disregard that bald denial and accept the defendant's fact that they relied upon the plaintiff's statements. But if the district court accepted the plaintiff's denial and said, I'm going to accept that, okay, and I'm going to find a dispute of material fact on that issue, is there appellate jurisdiction to review that in the qualified immunity context?
No, Your Honor, there is no jurisdiction.
What case supports that proposition? What's your best case to say that there is no appellate jurisdiction, even if the district court erred in determining that there was a dispute of material fact?
Yes, Your Honor. I think there are a number of cases. There's Johnson v. Jones from the Supreme Court that says determinations about sufficiency of the evidence cannot be reviewed on interlocutory appeal. And then a multitude of cases from this circuit as well. There is.
But sufficiency of the evidence is a little bit different.
Yes, Your Honor. But in that case, the district court.
I mean, take a very simple example. There's, plaintiff says the light was red, okay? Defendant says the light was red. District court says, I find a dispute of material fact on that issue. There clearly isn't. Both sides agree, okay? But the district court says, I find a dispute of material fact. One side appeals and says the district court clearly made an error in determining that there was a dispute of material fact. Do we have jurisdiction to review that error?
So I think Scott v. Harris has identified a very narrow circumstance in which there is incontrovertible evidence in the record that directly contradicts the plaintiff.
Video evidence.
Yeah, and in that case, it is video evidence. That is a very narrow circumstance. And we do not have to decide exactly where that ends because that is absolutely not the case that we have here. And defendants have said that Mr. Savory's has presented no evidence, that he's relying on mere allegations that these statements were fabricated, but that is not true. There is ample evidence in the record, both that these statements were fabricated, and even if this court did credit them, that the defendants knew that they were completely and wholly unreliable. And if the court will indulge me, I'll get into a little bit of that evidence here. Ella Ivey is one of the individuals whose statements they rely on. She testified later during post-conviction proceedings where she directly denied that she ever made those statements to defendants. Again, Mr. Savory has said that he never made these statements to any of these witnesses. He also denied making statements that defendants attributed to him and put in their reports. Witnesses who they are not relying on here, Wendy Sankey, they wrote reports in which they said that she made different various statements that, again, she denied saying at deposition. Tina Ivey later said that Mr. Savory never made these statements to her. If we look at
I guess, are you tying that to the police officer's knowledge in 1977? We see cases all the time where witnesses come in 5, 10, 2, 8 years later and say, I never made those statements. That's not true. I knew it was not true at the time. That happens all the time.
Ella Ivey said she never made these statements to the defendant
in
officer in 1977. And then if you look at Ray Mason's statements, he is questioned on 5 separate times. 4 times, the first 2 and the last 2, he denies that he ever had any conversation with Johnny Lee Savory about these murders and that he knows anything about these murders. There is one single report from Defendant Cannon in which he says that Ray Mason told him on the morning of the murders, Johnny Lee Savory called him and told him that his friends were dead. He denies repeatedly making this, and then other officers called his uncle and confirmed that he was actually with his uncle the entire day from early in the morning until late in the evening and could not have received a call from Johnny Lee Savory. And then when these officers went and wrote that they verified with him that this call in fact never made sense, they wrote in their report that they verified the call never happened. Ray Mason told them that he was confused by Cannon's accusations and his tone. There is ample evidence in the record, both that these statements were never made and that the defendants knew that they were completely and wholly unreliable, because after this, they never used these statements. They never called these witnesses to testify, and they never brought them to trial because they knew these were not real statements. There was no probable cause here.
What's the period of illegal detention that you're claiming damages for here?
From the time of his indictment until he is convicted at his first trial, I believe, is the time period.
Okay, so it's just the few months, I don't remember exactly what the time period is, but the time that he was detained, I guess, in jail until the time of the trial in 1977.
Yes, Your Honor.
Right. So can I move on to a different subject on the coerced confession?
Yes, Your Honor.
What you cited a litany of cases in the red brief on coerced confessions, and what's your best case regarding the facts here that the police are? I mean, you're citing cases where an individual was deprived without sleep for 48 hours. I mean, I'm making this stuff up, but some of these cases are so wildly unanalogous to the situation here. What case should we look to as your best case for clearly established law in 1977 that the police officers knew what they were doing was unconstitutional?
Yes, Your Honor. I believe that the two strongest cases here that just if we want to look at a single case are Haley and Gallegos. But I also want to reiterate that what is required here is not one single case that is directly on point with all of the same circumstances and all of the same tactics used. This has never been required by qualified immunity.
Right, I understand.
Okay.
But it's hard to say, it's hard to say a situation where a defendant was, a criminal defendant was not fed for 48 hours is analogous to a situation where a subject who's interrogated is fed for lunch. And that's what I just see the red beat is trying to stretch from, this person was deprived of sleep for 48 hours and Mr. Savory only got 6.5 hours of sleep. So we can extrapolate from the 48 hours plus the hamburger, plus the fact that he was 14, plus the fact that he only got to meet with his father for a short period of time. We can extrapolate from all these other cases and say that what happened here was clearly unconstitutional. That's what I think you're trying to do, but maybe I'm wrong.
I think Your Honor is looking at a little bit too detailed level of specificity. Again, this is not required here. What is required under Tolan is fair notice. The courts have said for a long time that we must look at totality of the circumstances. And of course, there is never going to be a case with exactly the same circumstances and exactly the same tactics used. That does not mean that defendants are not on notice, that the tactics they are using are coercive. The Supreme Court has repeatedly provided guideposts that let defendants know, let officers know when their conduct is getting out of bounds. And then here, Haley and Gallegos are particularly on point. And these courts go into detail describing exactly why a 14-year-old like Johnny Lee Savory is unable to match the power of the law when multiple officers are up there interrogating him over 30 days in teams, asking him confusing, rapid fire, overlapping questions. And here, in this case, Haley talks about an individual, a 14-year-old who was interrogated from 12 a.m. until 5 in the morning, just 5 hours, much less than Mr. Savory here. And he was deprived of any supportive adult figure, just like Mr. Savory here. And he was... And there are factors, and those are the factors there, and Haley, that the Supreme Court said this has made this this interrogation coercive and unconstitutional. And Haley put defendants on notice here. In our case, there are additional factors that make this not just more coercive than Haley and Gallegos, but obviously coercive and unconstitutional. The officers here, Mr. Savory told them that he no longer wished to speak to him. They made it clear that he could not end this interrogation. They brought him back and they continued to question him. Your Honor has spoken about whether it matters if an individual is given lunch one day or not provided food for 48 hours. The district court found here that Mr. Savory was that Mr. Savory was denied adequate food. Over 2 days, he was given a candy bar and a hamburger. This weakened him and made it more likely that his will would be overcome, and defendants knew this. And they did multiple things to render Mr. Savory totally hopeless. They told him that he could go home if he took a polygraph exam. Then they subjected him to two separate polygraph exams that they knew had no valuable basis, and then falsely told him that the polygraph exam results implicated him in the murders. They took him to the bathroom where they stripped him down naked and forcibly pulled hairs from his body. They did not provide him with any adult advocate. His father came at one point and they were unable to communicate and yelled at him and left him more susceptible to the pressures of the officers here, and then left. He had no friendly adult with him at any point during the interrogation, and he was interrogated more or less continuously over 30 hours, except for 6 hours where he was left at a detention center to sleep on a thin mattress for less than 6 hours.
Can I shift to asking you about just one defendant? It's Bowers.
Yes.
Because the Supreme Court has told us we have to consider qualified immunity defenses based on each officer's conduct. And, we have this case law that what Bowers did at the end of his interrogation, he was all in Mr. Savory's face and accusing him of being a murderer, et cetera, et cetera. And he did not at that time, there is some evidence, have knowledge of what the officers before him had done. Should that lead us to conclude that Bowers alone is specifically entitled to qualified immunity? What do you say about Bowers?
The district court found that Mr. Bowers was involved in a conspiracy to obtain a false confession from Mr. Savory. There is evidence in the record that supports that Mr. Bowers was aware. He was briefed by defendant Tepplitz about what had happened earlier in the interrogation. He was a former police officer who had worked closely with his officers, and he was present at the police station. A jury, this must go to a jury to decide exactly what role Mr. Bowers had in this interrogation, but a jury could conclude that he was aware of and was acting with together with the other defendants to interrogate Mr. Savory.
Does your answer flow because there is the presence of the conspiracy charge, or even if there wasn't the presence of the conspiracy charge, we should still find that Bowers is not entitled to qualified immunity?
I think even without the conspiracy, there is evidence that he was aware and was working as part of this team to interrogate him. But I think those go hand in hand with the conspiracy. I'm not quite sure if they're separable. So I believe here there are no distinguishing factors there are no meaningful distinguishing factors that between Mr. Savory's case and Haley and Gallegos. And then there were multiple additional factors that have been clearly identified as coercive. Yes, the court still has to consider the totality of the circumstances. And yes, the officers have to consider the totality of the circumstances. But under these totality of the circumstances, the officers were on bare notice that they were violating Mr. Savory's constitutional rights. I'll say briefly with regard to the destruction of evidence, that is premised completely on a dispute of fact here. Mr. Savory, the district court found that there was evidence that the defendants would have been aware of the exculpatory value of the evidence. One, that there was no blood on the pants, and two, that the hairs were, the defendants themselves, through their probable cause arguments, are arguing that the hairs are able to implicate the true perpetrator of the
Does that claim only arise, though, in 2013?
No, that claim arises when he could have used at any point that he could have used the evidence.
Did he ever ask to use? I mean, in other words, what I'm troubled by is, let's assume the evidence was destroyed in 1977. What difference does that make if nobody asked to make use of the evidence until 2013, I think?
I don't think it makes a difference, because at that point he was deprived of his ability to test the evidence, which would have been.
But he never asked to test the evidence. I mean, that's suggesting, wow. I mean, that is such a broad statement, because police get rid of evidence all the time. And clearly in 1977, there was no established case law that said they have to keep all evidence forever.
That's correct, Your Honor, but the law does say that they have to maintain potentially exculpatory evidence and that they cannot destroy it in bad faith. Here, defendants are not disputing that they acted in bad faith. For good reason, there's ample evidence that they acted in bad faith in this case. And the potential exculpatory evidence, value of the evidence was more than apparent. Plaintiff has argued that defendants fabricated that there was blood on the pocket of the pants. This was not challenged at summary judgment. That claim will go to trial.
But not in 1977.
Yes, Your Honor. The plaintiff is
No. In 1977, the plaintiff asked for the pants, and the police said we can't find them. No, I don't think those are the facts, right? I think in 2013, around then, the plaintiff asked to have DNA testing on the blood because he said it would exonerate him, and the police said we don't have it. And so, for the purposes of our analysis, we have to assume that they didn't have it as of 1977. But there's no evidence of that.
The evidence was destroyed, and that has to be accepted. Mr. Savory could have used.
I understand that.
And Mr. Savory could have used the pants at any point, including in 2013.
Did he ever ask to use the pants before 2013?
Not that I'm aware of, and not in the record. But in 2013, he asked to test the pants, and he would have been able to show that there was in fact no blood on the
But
pants.
I got it, but if we accept that argument, don't we have to accept that the police had to keep the evidence from 1977 until 2013, anticipating the DNA testing would be available at some future point, and that perhaps he would be exonerated?
I don't think they would have had to anticipate that DNA testing would have been available, because just the testing to show that there was no blood on the pants would have been exonerating of Johnny Lee Savory.
Okay, but is it your contention that the police knew in 1977 that they had to keep the pants for 50 years?
They did know that they had to preserve the pants, and they did know that they could not destroy them in bad faith. Well, Peoria's policy here, I believe, required them to
Forget the
preserve.
policy, I'm talking about the United States Constitution.
Sure, I think they have to preserve it in perpetuity, I believe.
In perpetuity, okay. That's what I thought your argument was, and I don't think there was anything in 1977 that would require police officers to keep evidence in perpetuity. But I might be wrong.
And if I understand your argument is there was testing available in 1977 that could have just shown there was no blood on the pants, and that is what could have been available to Mr. Savory.
Yes, Your Honor. Yes, Your Honor.
And do you agree with the defendant's lawyers that they're asking us to make an inference that the evidence was destroyed in 1977?
I don't think it matters whether the evidence was destroyed in 1977 or at some point in between, but I don't think it matters here.
Thank you, Ms. Pierce. Mr. Sotos, we'll move to you now for a rebuttal argument.
Thank you, Your Honor. I'm going to briefly try to supply the court with some items that it had asked for throughout the argument. Johnson versus Jones. This is what Johnson versus Jones says. This is a quote, that the collateral order doctrine, quote, occasionally requires a detailed evidence-based review of the record. I think that this case, if you look at Taffy versus Wenger, this is the kind of case where that edict might apply. Again, we have tried to argue why probable cause law settles the issue, but between Johnson versus Jones and Scott versus Harris and the way that the Sixth Circuit interpreted those in Rodriguez, this is in our brief, the way the 11th Circuit interpreted them in Taffy, we think that sets a nice framework for analysis of an inadequate finding of fact in this case. The September 1977 ports, Judge Jackson Akumi, those are dockets 320-39 and 320-40. The notion that the destroyed evidence could have been destroyed at any time and we don't need to timestamp that belies the test for destruction of evidence. And the destruction of evidence test from Youngblood, from Trombetta, specifically says that we need to know about exculpatory value, whether the officers knew of exculpatory value at the time of destruction. The only evidence in the record of when these items went missing comes from 1977. There's some discussion in the trial record about these items being missing in 1977. The test requires us, for qualified immunity purposes, we are just trying to see if the officers had a duty to preserve from that point on. There was quite a bit of discussion about the fabrication, the witness statements themselves. Ella Ivey maintained in this case, in her deposition testimony, that the statements we rely on that are in our brief that we have provided the court were truthful. I sympathize with opposing counsel, our lawyers, the court. This is an unwieldy record. This is a very difficult record. It is extensive, it is expansive, it is old, which creates its own issues. However, we lay this out in our brief. One of the concerns with simply deferring to factual presumptions made is that you lose the genuine viability of entitlement to immunity in a messy record.
That's why they allow interlocutory.
This is the reason why the collateral order doctrine allows me to be here. There are defendants in this case. There are some claims that are going to go to trial against some defendants. There are other defendants in this case. If qualified immunity is resolved in their favor, they are out of the case. If the coerced confession claim goes away, Sergeant Andrews is likely out of the case because he's only in on a failure to intervene claim in the coerced confession. If Sergeant Bowers is found qualifiedly immune, we have significant doubts about the viability of the conspiracy claim against him in the lower court. Mr. Jackowski, we emphasize the individuality of Bowers' actions in the brief. We think Sergeant Jackowski deserves a particularly strong look about the constitutionality of his tactics in the coerced confession case. All he did was essentially get evidence from Mr. Savory's person. He wasn't involved in any of the questioning of any of that sort. If that claim is resolved in his favor, he is very likely to be out of the case. Indeed, Ms. Teplitz may well be out of the case. We don't believe that she's part of the 1981 fabricated confession claim if these claims are resolved in her favor. So this is a long way of saying the qualified immunity doctrine and absolute immunity in some ways, The purpose of it is to resolve claims that are not viable for which officers did not have fair notice before trial, before they have to face a trial. And I appreciate that the Seventh Circuit has some case law saying that we defer to the district court's findings of fact. However, over-deference, overindulgence of a messy record, it deprives entitled defendants to immunity that the Supreme Court has held for decades. They are due where there is not clearly established law. There will be a trial. Some of these defendants will have to face that jury. But some defendants can be out of the case now if the court will exercise jurisdiction and rule in their favor. So for the reasons articulated in our briefs, we would ask the court to reverse the 4 denials of immunity in this case. And for those defendants who shouldn't go to trial, let them be done. Thank you.
Thank you, Mr. Sotos. Thank you, Ms. Pierce. The case will be taken under advisement. We'll now move to Appeal 24-2898, Gills versus Robert Hamilton et al. We're going to begin with oral argument from the appellant, Mr. Leaf. Mr. Leaf is appearing remotely. Mr. Leaf, I understand you have reserved 5 minutes for rebuttal.
That's correct, Your Honor. Thank you.
We can hear you, and opposing counsel can as well. Mr. Leaf, I'll recognize you.
Thank you. May it please the court, counsel. My name is Roy Leaf. I'm an attorney at the Nyemaster Good Law Firm in Iowa. I represent Jeran Gills as his pro bono counsel. He is the appellant in this case. First, I want to thank the court for allowing me to appear via Zoom. My wife works in the medical profession and works odd hours, making childcare difficult at times. I plan to address 3 issues today. First, I will explain why the district court erred in denying Mr. Gills' partial motion for summary judgment against the IDOC defendants because the conditions in the medical segregation cell in which Mr. Gills was kept at East Moline Correctional Center for 31 days were unsanitary, below the basic human standards of living, and violated the 8th Amendment as a matter of law. Second, I will explain the numerous genuine issues of material fact that exist with regards to Mr. Gills' claims against Dr. Rankin and the IDOC defendants. The district court committed clear reversible error by granting summary judgment to the IDOC defendants and Dr. Rankin, and its decision amounted to impermissible credibility determinations at summary judgment. Finally, I will address why genuine issues of material fact exist with regards to Mr. Gills' civil conspiracy claims against Dr. Rankin and the IDOC defendants. First, the decision on whether to reverse the district court's grant of summary judgment to the IDOC defendants and Dr. Rankin is frankly an easy one for this court. Even putting aside the fact that the district court completely ignored Mr. Gills' testimony, which I will address.
Is that the deliberate indifference claim, Mr. Leaf? Are you talking now about the deliberate indifference claim?
Yes, thank you, Judge. The deliberate indifference claim.
Okay, what is the specific medical condition to which the IDOC defendants were deliberately indifferent?
The medical condition they were indifferent to was his broken arm, which had a femur fracture. He had 2 orthopedic surgeries to repair it, and he was recovering from that. He also had some wounds from an assault, and there was also denial of certain medications by one of the IDOC defendants, Dunn, who did not bring him pain medication for those injuries or Pepsid, which he was prescribed. So the decision to reverse I believe is easy. Even putting aside the fact the district court disregarded Mr. Gills' testimony almost completely, the district court failed to consider, among other things, the declaration of Leroy Smythe. Mr. Smythe was a medical porter at East Moline Correctional Center who was assigned to clean and do basic functions for the cell that Mr. Gills was confined in for 31 days. Mr. Smythe testified via declaration that he saw guards refuse multiple times to take Mr. Gills to the bathroom, that he cleaned feces and urine out of milk.
What does that have to do with the broken arm, the assault wounds, or the pain medication?
Your Honor, that has to do with the conditions of confinement claim, the 1983 conditions of confinement claim. So Mr. Gills brings two varieties of the 1983 claims. There's both a conditions of confinement claim and a medical indifference claim.
Right, and okay, on the conditions of confinement claim, I'm confused a little bit on what is exactly the plaintiff's Eighth Amendment right or claim that he's alleging. Because I read from your brief that his Eighth Amendment right to be right from the free of the risk of infection. Is that correct?
That's correct, Your Honor. Right to be free from risk of infection, also right to have basic sanitary environment to be housed in.
Are there any cases anywhere that you can cite to that say that a defendant has an Eighth Amendment right to be free from the risk of infection?
Yes, Your Honor. I believe that in my brief, I've cited the cases that say that there is a risk to be free. There is a right to be free from the unnecessary risk of infection. That goes beyond the punitive nature of punishment, and that crosses into cruel and unusual punishment.
Is this rule that you're promulgating effectively a per se rule?
No, Your Honor. I believe it's a facts and circumstances test. I believe here it's important that Mr. Gills was in a compromised medical condition, so his height of infection was or his risk of infection was materially heightened by the fact he just undergone 2 orthopedic surgeries and had open wounds on his arm, on his face that are documented.
So specific to him and his circumstances, being injured in a med-seg unit with the allegations with regard to the ability to have a toilet.
That's correct, and a sink or some way to sanitize his hands. He had no way. There was a plastic urinal provided to him, which I believe is a recognition that he may need to use it from time to time, which he did, and that there was no way to sanitize his hands even after he used the facility he urinated. That creates a risk of infection. I think that's both medically and just common human sense applicable.
I wonder, do you think this right existed 150 years ago, the right to have a toilet in your cell? Or is this an evolving right? Or how do we figure this out? I mean, I get the unsanitary conditions, but the unsanitary conditions here are not that he wasn't able to use the toilet. It was that, at least the way I understand it, was that he didn't have a toilet in his cell. Really, that he didn't have running water in his cell. So after he used the portable urinal, he was not able to wash his hands, which increased the risk that he might be infected, even though he was never infected. And therefore, there's a constitutional violation, and he has a claim on the Eighth Amendment. I'm having trouble putting all those things together and then thinking, boy, has that been the law for 150 years, or is that new? Where does all that come from?
Yeah, Your Honor, it's a good question. I think there's 2 ways to approach it. I think if you want to approach it from the standards of evolving decency, I think in 2025, it's a basic human right to have working plumbing and a sink. Approaching it though from looking 150 years ago or 200 years ago, was that there? No, there was no plumbing, but I believe the Eighth Amendment did protect individuals from being free from unnecessary risks that go beyond and having clean cells.
Yeah, and I'm not talking about plumbing per se. I'm talking about a toilet in your cell. Clearly, if a prisoner had no access to a toilet or no access to running water, that probably would have been a problem 150 years ago. But I'm not sure that prisons were constructed with toilets and sinks in individual cells. That's all.
Yeah, Your Honor, and just to make a distinction that I think is important, for purposes of Mr. Gills' motion for summary judgment, obviously all facts have to be assumed in favor of the IDOC defendants and Dr. Rankin. They'd alleged that he was offered the ability to use the bathroom every 30 minutes, that there were no issues. Nobody was aware of the fact that he ever defecated, urinated, vomited in his cell. Now, going to the defendants.
Can I ask you a question about that? I want to make sure. In your brief, do you argue that the officers were aware that Mr. Gills was not being taken out regularly for bathroom breaks, or that they failed to provide reasonable measures to clean up? In other words, the defendants that you sued, in your blue brief, I had a hard time finding where you argued that they were aware of any potential constitutional deprivation.
Judge, we actually argue they intentionally refused to take him to the bathroom. There's evidence that multiple defendants, multiple times for entire 8-hour shifts, would refuse to take him to the bathroom when he asked, so that they would be aware that he would have to do his duty in the cell otherwise.
And the record shows that in that 30 days that he was in the segregation unit, there was one grievance from him. Is that correct?
I believe that's what the record reflects. Yes, there was one grievance from him.
Let me ask you about where you're locating your Dr. Rankin arguments, because in your brief, you know, you don't list him in the section that's about conditions for confinement. Are you asserting that conditions of confinement claim against him, or is it just deliberate indifference for him, and then you're arguing that he was deliberately indifferent to the effects of the conditions on Mr. Gills' medical state?
Judge, it's a two-part argument. So the first part would be, yes, deliberate indifference to the various medical conditions that are cited in the brief, and I'm happy to expand on those further. There's also, I believe, deliberate indifference to those conditions, but as an alternative, there is also a conditions of confinement claim that being a medical professional, Mr. Gills, again, viewing evidence in the light most favorable to Mr. Gills testified and put in his declarations that he multiple times told Dr. Rankin about the conditions of the cell, the fact that he was urinating, defecating, and that Dr. Rankin did nothing about that, even though he had the ability, as the warden testified, to bring a portable toilet in to that cell. He didn't do that. And so as a medical professional, even I believe, basic common sense, but as a medical professional in particular, he should have been aware that the conditions of those cells created a heightened risk of disease, were not proper for somebody in Mr. Gills' medical condition. And so therefore, there's an Eighth Amendment violation also of conditions of confinement with respect to Dr. Rankin. I see that at my 10 minutes is approximately up. I will reserve the remaining 5 minutes, and I can address Mr. Gills' civil conspiracy claim during that time.
Very good, Mr. Leaf. Thank you. We're now going to move to the argument from the appellee. We'll begin with Mr. Freelick.
Good morning, Your Honors. Matt Freilick for the state defendants. The court should affirm the district court's judgment. The district court correctly granted the state defendant's motion for summary judgment on each of Gills' claims against them, and also correctly denied Gills' affirmative motion for partial summary judgment on his conditions of confinement claim. And I wanted to focus this morning on the substantive conditions claim.
Before we get there, let's talk a little bit about the summary judgment record. Much discussion of James versus Hale. Is it your position that James versus Hale creates a new rule different from the sham affidavit rule? There's an extension of the sham affidavit rule. I'm trying to get a feel for what your position is on the reach back complaint verification question. Is that dicta, holding? What is it?
So I think in one sense it is dicta, Your Honor, and it's something separate from the sham affidavit rule. There's a well-established body of precedent that governs when that rule applies, and it focuses on contradictions, generally between the plaintiff's summary judgment affidavit and their deposition testimony, in some cases other parts of the record. That is not the doctrine that the district court relied on to disregard Gills' supplemental declaration in this case. She was relying on a separate part of the opinion in James, and James ultimately upheld the disregarding of a declaration based on the sham affidavit rule, but there was an entire separate section of the opinion, and I'm referring to part 2A of the opinion, where it discussed this, what it termed a reach back complaint verification procedure. So I think a reasonable district judge working with that part of the opinion in James versus Hale could have reached the same result that the district judge reached in this case. I certainly acknowledge that there's a distinction between what happened in James and what happened here. In James, the affidavit literally swore that the allegations in a pleading were true. In this case, the plaintiff copied almost verbatim the content of the operative complaint into a summary judgment declaration. I think a reasonable judge under those circumstances could read James versus Hale to allow her to make that ruling. But I do think that regardless of whether the supplemental declaration should have been part of the record, I don't think it's outcome determinative. even if the court were to disagree on that threshold ruling, or if the court were to decide to pass on that question entirely and just assume the expanded version of the record for addressing the merits, I think the outcome will be the same, and the judgment should be affirmed either way. So on the merits, again, regardless of the state of the record, the district judge's rulings on the summary judgment motions was correct because the evidence that Gills presented did not establish a genuine issue of material fact that any of the state defendants had subjective knowledge and was deliberately indifferent to an objectively inhumane condition that Gills experienced when he was in medical segregation. I want to begin on the merits by addressing the objective prong of the analysis, and specifically to pin down exactly what Gills' theory of liability is on the Eighth Amendment. I think that's going to be very important when it comes to the subjective component and ascertaining what exactly Gills' summary judgment burden was when it came to evidence of the Eighth Amendment violation. Gills' theory in the district court, and the theory he is continuing to press on appeal, at least in his opening brief, was that his Eighth Amendment rights were violated because he was incarcerated in a cell that did not have a sink or a toilet inside of it, which he says violated the Illinois Administrative Code. And I'll assume the code violation for the sake of argument, but even making that assumption, that theory of liability is still wrong on several grounds. The first being that Eighth Amendment violations are not determined by reference to state administrative requirements. I know Gills cited a case from the District of Massachusetts to argue otherwise. Whatever the state of the law in the First Circuit, the law in this circuit is clear that these two things exist in separate spheres. And second, even putting the administrative code aside and just focusing on this court's relevant precedents, it doesn't follow from those precedents that an inmate has the specific right to have a toilet and sink inside his cell. I think the closest cases on point on that issue are Jackson versus Duckworth and Vinningell versus Long. Both of those cases fit into a broader line of authority, recognizing an Eighth Amendment right to minimally sanitary conditions. They fall well short of establishing that an inmate has the more specific right to have restroom facilities located inside his cell, and that right is violated if he has to use the facilities elsewhere inside the prison. And then finally, Your Honors, even if the court were to hold that an inmate does have that more specific Eighth Amendment right, that wouldn't support liability against the defendants in this case, because if that were the claim, at that point, qualified immunity would come into play. We did raise qualified immunity in the district court. We raised it again in our brief in this court. And regardless of whether Jackson and Vinningell could be extended to create that more specific Eighth Amendment right, that right absolutely was not clearly established in February or March of 2020 when the alleged constitutional deprivations occurred. I want to move on to the subjective component of the analysis next, and Gills' arguments on this component of the test fail for a similar reason that his arguments were deficient when it comes to the objective prong. Gills argued in his brief that the defendants were liable because they had subjective knowledge that his cell did not have a sink or a toilet inside of it. And he sought to hold them liable on that basis. That was his argument in the district court. That's his argument in this appeal. But as I just explained, that circumstance itself is not an Eighth Amendment violation. So the defendant's subjective knowledge of that circumstance would not have put them on notice of a constitutional deprivation in a way that would subject them to 1983 liability. I do want to draw a distinction between, on one hand, just all of the facts that Gills discussed in his brief, and on the other hand, what his actual theory of liability is. Because Gills does mention that he relieved himself in his cell on occasion, and that certain of the defendants denied his requests to use the restroom on occasion. However, when it comes to the theory on which he's seeking to hold the state defendants liable, that theory is that they were subjectively aware that there was an administrative code violation and that he was housed in a cell that didn't have a sink or a toilet inside of it. And finally, Your Honors, I know our brief discussed what would have happened if Gills had advanced this alternative theory of liability, where the Eighth Amendment harm is actual unsanitary conditions inside the cell and not just the mere lack of a sink or a toilet, essentially an administrative regulatory violation. Even if that had been the theory that Gills was advancing, and I want to be very clear that it's not, that still wouldn't have supported liability because the facts wouldn't have supported a reasonable inference that the defendants were aware of that much more specific fact. At that point, Gills' evidentiary burden, when it came to the subjective prong of the analysis, would have been considerably higher. And he would have had to address liability defendant by defendant because the defendants absolutely were not similarly situated when it came to their knowledge of what was actually going on inside Gills' cell. They each interacted with him in different ways, and many of them were not even assigned to duty in the healthcare
What
unit.
you're referring to is pages 29 and 30 of the blue brief.
I am. Yeah. So I think in terms, if the court is trying to ascertain what exactly his theory is, and to be specific, what is the factual link between what he's saying the Eighth Amendment violation was and what the defendants were aware of in a way that would make them liable, it's the knowledge of the administrative violation. And for the reasons I discussed earlier, that just on the objective prong of the analysis is wrong. Gills is not arguing that the defendants had subjective knowledge of a further circumstance. And I don't think the court is under any obligation to consider that theory. I know we discussed it in our brief, but Gills did not discuss that in his. And even when we raised that point in his reply brief, I think he makes this clear on pages 3 to 4 of the reply. He's doubling down on his theory that the Eighth Amendment violation is basically tantamount to the administrative code violation. In other words, I'm
just curious, its summary judgment in discovery in this case, was it litigated differently? Was it litigated as if individual defendants denied Mr. Gills the opportunity to go to the bathroom repeatedly over long periods of time and were aware that he was not being taken out of the cell to use the toilet or to use the sink?
I think the theory is essentially the same. So I think both in the district court briefing and here, he does state as a matter of fact that certain of the defendants refused his requests to use the restroom.
Yeah, but that doesn't necessarily lead to an Eighth Amendment violation without significantly more. And was the significantly more litigated in discovery in the district court, or was it not?
So I want to separate the litigation and the summary judgment briefing from the discovery. I think there were facts that were reduced in discovery that had Gills made other strategic choices, he might have tried to advance that theory. For the reasons I discussed, I don't think that would have been successful. In terms of what he actually argued to the district judge, that is not what he argued. He didn't go defendant by defendant. He said that they were each aware of the administrative code violation. And for those reasons, I think the district judge's rulings were correct on the summary judgment motions, and the judgment should be affirmed in its entirety. I want to be mindful of my colleagues' time. If the court has any further questions, I'm happy to address them. If not, I'll see the remainder of my time. Thank you.
Thank you, Mr. Freilich. We'll now move to, is Mr. Kriak? Great.
May it please the court, Patrick Craig on behalf of Dr. Rankin. The district court's order granting Dr. Rankin's summary judgment should be affirmed. To answer Your Honor's question about James versus Hale and reachback complaint verification, to add additional color there, I think there's two bases in James versus Hale as to why that affidavit was stricken. One, because it contradicted prior testimony, and two, because the supplemental declaration constituted inappropriate reachback complaint verification. So in terms of James versus Hale's impact, I think it's a reinforcement of the sham affidavit rule and striking contradictions with prior testimony. I think its impact is more recognized for the reachback complaint verification aspect, because it commented on the case of Ford versus Wilson, where the inmate in that case did not have counsel, and because he swore to the allegation in the complaint as true, the court accepted that affidavit in that case despite it constituting quote unquote reachback complaint verification. But what James versus Hale decided was, in cases where the plaintiff is represented by counsel and there's a long history of discovery in the case, it's going to not be as accepting as represented counsel doing what happened here, which is looking back to the complaint and adopting those allegations as facts appropriate for summary judgment.
Do you agree with Mr. Freilich that it's dicta? But it's because obviously there's treatment of that earlier case at the beginning of James versus Hale. And the work was done by Judge Sykes to point out that those were counsel versus non-counsel cases, or non-counsel versus counsel cases. Do you agree, though, that extension is dicta, or do you think it's holding?
I think it reads more like dicta when you read the opinion, but I do think that there's multiple bases from James that were applied by the district court here as to why the affidavit was stricken, both because there was contradictions between the testimony and the supplemental declaration, and that declaration amounted to adopting the allegations in the complaint wholesale as facts appropriate for summary judgment, even though they contradicted the facts that were adduced throughout the process of discovery. I'm happy to address the claims against Dr. Rankin of conditions of confinement and civil conspiracy, as that is what counsel brought up here today. I'm also happy to stand on my brief with respect to those claims. I think the deliberate indifference to serious medical need claims, what's more discussed in the briefs. And on those points with Dr. Rankin and what counsel argued in his reply brief, his first contention is with respect to just because there was a lot of appointments with Dr. Rankin and other treaters at EMCC, Gills argues that perfunctory appointments don't necessarily constitute meaningful medical care, and he cites in support this court's decision in Perez. Few problems with that. Perez was an appeal of a merit screening review order at the outset of the case, and didn't have any. There was no discovery in the case, and the defendants hadn't even been served in that case. And this court determined that at screening review, just because there are a lot of appointments doesn't necessarily mean that the claim should be, there's a failure to state a claim, because the care might not have been meaningful, even though it happened a lot. But in this case, there was discovery, and it revealed that the care that Dr. Rankin and other treaters provided at EMCC was far from perfunctory. So the comprehensive course of care he received from the date of his injury for over 5 months in the infirmary and then follow-up care thereafter did not constitute negligence, let alone deliberate indifference. We cited in our brief, as a point of comparison, the case of Kashner versus Whiteup, this court's decision in 2017. And in that case, over a span of 6 months, there were 17 telephone orders and 6 in-person appointments. Here we have, in a more brief period of time, much more appointments, much more orders, and Gills is noted in the medical records as stating that the treatment helped him throughout the course of care, and his fracture ended up healing. And the record here shows that this was not even negligence, let alone deliberate indifference. And then in Gills's reply, he also asserts that the November 21st, 2020 note, the first time that Mr. Gills complains of any pain following his discharge from the infirmary, states that that provided subjective knowledge to Dr. Rankin of the joint stabilization hardware somehow causing the pain. And I think that this court can dismiss that argument for 3 separate reasons. One, because that note doesn't provide any subjective knowledge or evidence of subjective knowledge that the hardware specifically was causing the pain. Secondly, his response was reasonable. He referred him for physical therapy, which he had not yet received because of the COVID pandemic, and that PT led to him actually getting the hardware removed. And third, because that is a claim for delayed rather than denied medical care, he needs to introduce verifying medical evidence to allow a jury to determine that the delay specifically caused the pain and not the underlying arm fracture that the orthopedic treater said throughout the course of care there was no guarantee that the arm will return to full function and be without pain. So if there are no other questions, we ask that the court affirm summary judgment in favor of Dr. Rankin.
Thank you, Mr. Craig. Mr. Leaf, we're going to move back to you now for rebuttal argument.
Thank you, Judge. A couple points I'd like to make, and I'll start backwards with counsel's argument regarding Dr. Rankin. I do want to note it was more than just a medical note on November 21st, which is, to be clear, approximately 5 months after Mr. Gills had the hardware inserted into his arm, which is also well outside of the 8 to 12 weeks that the orthopedic surgeon said the device needed to be removed within. During that meeting, it was noted that there was arm discomfort by Mr. Gills, and not only was there a note, but Dr. Rankin testified to it in his deposition. I believe that is cited in my briefing. With regard to the multiple follow-up appointments that Dr. Rankin's counsel noted, I believe the Perez case is obviously on a different factual proceeding, but that court makes clear that if a medical professional could just simply schedule appointments and do nothing during those appointments, it could discharge its Eighth Amendment obligations without actually rendering medical care, which would be an end around of the Eighth Amendment. So I do believe Perez is still good. I also want to note, with respect to the sham affidavit rule and the application of Hale, the illogical conclusion that would be reached here. After I was appointed, I did an investigation with my client, reviewed the record, and put together a 43-page amended complaint that had 11 exhibits to it to both put the defendants in the court on notice of what I saw were significant issues here. The conclusion of applying the district court's ruling here is if instead I would have done a very simple amended complaint that would have barely satisfied the requirements of Rule 8 and then put together declarations in substantially the same form as they were submitted here, that would have been acceptable. But because I filed a fulsome amended complaint and then used those same allegations when they were verified during the course of the case or not contradicted, that created a problem. I don't believe that is an appropriate rule to make here. I believe that's perverse to the reasons that we're here, which is to search for truth and justice, and that counsel should be encouraged at an early stage of the case to put forward facts that come to light both during discovery.
Mr. Leaf, permit me, am I missing something? Is there a reason those statements that you added to the declaration and you say, they were part of this amended complaint, is there a reason they could not have been addressed during discovery, for example, during Mr. Gills's deposition?
Yes, Your Honor. The defendants could have asked Mr. Gills during his deposition. They could have gone through the amended complaint and asked him line by line, do you recall this? Do you remember this? What do you remember about this? And tested his recollection. They didn't do that. He wasn't presented with many documents at all. And one of the things that he says, in one of the two contradictions that are noted, he says he doesn't recall without documents what date something happened. So there weren't any blatant contradictions. They could have been asked. To the extent that I would have needed to essentially depose my client to get that information out on the record rather than putting in via declaration, I don't think that's necessary, appropriate, or what's typical practice on a case like this. I also want to address the issue of subjective knowledge that was raised by the IDOC defendants. There are two prongs. Yes, counsel is correct that one of the reasons I believe that there is subjective knowledge here is each of the IDOC defendants, other than Dunn, had specific training on the Illinois Administrative Code, were aware of the requirements in segregation cells that they needed to have a sink and a toilet.
But Mr. Lee, that's your argument. That was the question that I asked earlier on pages 29 and 30 of your brief. You don't argue anywhere the question that I asked, which is, where is the argument that specific defendants were aware that your client was not being able to use the toilet for extended periods of time, was not being able to wash his hands? They don't appear in your blue brief. You simply argued that they were aware that he didn't have a toilet and sink in his cell, and that's enough to establish a constitutional violation.
Your Honor, you're correct that they were not specifically addressed in my brief. They were, I believe, raised at the district court level, where I did walk through each defendant and their subjective knowledge. For example, the warden, defendant Hamilton, received the grievance from Mr. Gills. He was made aware that he didn't have a sink or toilet. The assistant warden was making rounds on the medical floor. There's evidence that Mr. Gills went to the assistant warden and said, I don't have a sink or toilet here. I'm not being asked to use the bathroom. There's also, as I indicated in my opening arguments, the evidence regarding specific defendants intentionally refusing to take him to the bathroom. So you are correct. It's not addressed in my opening argument. It was presented and litigated at the lower court level. Finally, with regards to my civil conspiracy claim, I see I'm running out of time here, but I would like to just quickly note that obviously conspiracy is proven by circumstantial evidence. There's a number of circumstantial pieces of evidence here that are directed to in my brief that I think are clearly sufficient from a summary judgment perspective. And with that, I'm out of time. I'm happy to answer any questions, and I appreciate the court's attention to this matter.
Thank you, Mr. Leaf. You have the great thanks of the court for accepting this case, for your fine representation, as well as for the fine representation of the state. And the case will be taken under advisement. We're now going to move to our third case of the morning, Appeal 25-1279, Wisconsin Voter Alliance et al. Versus Don Millis et al. Mr. Cardall, we begin with oral argument from you.
May it please the court, good morning. My name is Eric Cardall. I represent the Wisconsin Voter Alliance, Ron Hoyer and Kenneth Brown. This appeal is about their Article 3 standing to bring their 1983 claims in the district court. To begin, the Help America Vote Act was enacted pursuant to the Elections Clause by Congress to regulate state administration of federal elections, including statewide voter registration systems, related databases, voting machines, and administrative procedures. It's quite a broad law. In this case, the Wisconsin Election Commission's denials of hearings and final determinations on Wisconsin Voters Alliance HAVA administrative complaints is an actual concrete and particularized injury for the purpose of Article 3 standing.
Let's unpack that a little bit. I'd like to ask you some questions, Mr. Cardall, on the different types of injuries in fact that the appellants are arguing. First, actual intangible injury. Are you aware of any cases permitting standing on an actual intangible injury theory for a violation of statutory rights without an underlying express right of action?
I'm aware of the case saying there's no 1983 claim to bring in this court to have a hearing and a final determination on merits of a HAVA administrative complaint. That's for the state administrative procedures.
Right.
What we're here complaining about is that the Wisconsin Election Commission is denying us the hearing and the final adjudication. So the cases that I'd refer to are cases involving interpreting statutes to see if they have a substantive right that's enforceable under 1983. There's a three-factor test. The first test is there a unambiguously conferred right? And here the unambiguously conferred right is on the HAVA complainant to have a hearing and an adjudication on the complaint.
My question is more particular that it goes to an express right of action. And are you submitting that the right of action that would underlie a violation of statutory rights is in and of itself the Wisconsin statutory section?
No, it's the federal law saying that once the complaint is filed, on the request of the complainant, the government shall have a hearing on the record and make a final determination within 90 days of the complaint. So Congress chose those words to create a statutory mechanism for HAVA complainants to have a remedy under HAVA, and that's federally guaranteed. That's not vague or ambiguous or amorphous. The court here listening can understand what I'm asking for, a declaratory judgment requiring Wisconsin Election Commission upon a HAVA complaint to comply with the HAVA provisions requiring a hearing on the record and an adjudication within 90 days. Also, there's an unambiguous imposition of a binding obligation on the state. The use of the word shall with respect to the hearing and with the final determination within 90 days is not discretionary. Usually, this would be sufficient, but I did want to remind that Gonzaga mentions, and this is the related 1983, that you also look for a private right and a remedy. So here the private right is to file the complaint, have a hearing and a final determination. That is the congressionally intended remedy, the way to enforce HAVA for this class of complainants.
So WEC did understand what you were asking for, and we do too, but you argue that the options they gave you instead, because they said, hey, we can't do this, you argue that those weren't really viable alternatives. So let me shift you there.
That's a great, thank you.
Can you explain why?
Yeah, so when the Congress says you're going to have state administrative complaint procedures, that's what the title of it is, and it says, state, you're going to receive an administrative complaint, and you're going to have a hearing within a certain number of days and a final determination. That's a command from Congress. And so the command from Congress through HAVA is you shall do this. And quite frankly, and I told my clients, listen, you would too, that administrative complaint procedures tend to be cheaper and faster than court proceedings. So I've done these HAVA administrative complaint procedures in states like Minnesota and Pennsylvania before administrative law judges. They really go smoothly. And it's a very good thing because sometimes you're pointing out something that the government hadn't thought of. Sometimes the government agrees with you. Sometimes you learn something you didn't know. And it's a very good thing. The actual harm to the complainant is that they don't get the hearing and they don't get the final determination. And for Wisconsin Voter Alliance...
Isn't that just a procedural violation, though?
Oh, yes, but that's a good question. But the argument from the government misses the point that the mere procedural violation we're talking about is setting up a private right to bring an administrative complaint against state election officials of violating HAVA and a hearing and a determination within 90 days. So that's not a mere procedural violation. This is a concrete right. Now, I agree, it's legal concrete, but nonetheless concrete in the idea that when Congress engages in the American tradition of codifying the petition to redress the government for grievances, and it's done many times, the court knows that, the Federal Tort Claims Act, the Tucker Act, the Freedom of Information Act, Section 1983, the Driver Privacy Protection Act.
But they were able to do that here. They are able to petition the government. They just don't like the government's response.
But Congress codified the petition, just like in the Tort Claims Act. The Tort Claims Act, this court shall adjudicate those claims. In HAVA, this state shall administratively adjudicate these claims. So when you have a tradition, and by the way, Spokio mentions, this is kind of a tough case in the sense that when we're looking at whether these rights are concrete and they're actual, that history and Congress's judgment is the court's guide. So the history of the United States, thankfully—
Before we get there, let's talk about actual tangible standing, organizational standing. Hippocratic Alliance came down. It's got to directly interfere with core business activities. Obviously, Wisconsin Voter Alliance is an issue advocacy organization. The argument that I understand you to be making is WVA uses government processes to educate, spur into action, encourage public officials, recommend certain laws. How has that been directly interfered with by the WEC?
So I think there's in the core activities, educating, investigating, revealing, advocating, lobbying, and so forth. And the methodologies include, communications, committee meetings.
How has that been interfered with?
Well, one of the tools they use, part of the tools they use in promoting their agenda is legal procedures like Open Record Act requests, Freedom of Information Act requests, 506 complaints, violation of state law, 1983 lawsuits, and HAVA complaints. And so with respect to the interference, when WVA is denied a congressionally guaranteed tool, then that's an interference with Wisconsin Voter Alliance's activities. The tool here is—
Let's unpack that for us, because WVA has filed more complaints since these have been returned, right? I'm thinking Mr. Hewer in his declaration at paragraph 52 talks about the fact that there was this complaint made about the UW Parkside situation. So WVA continues to do this, right?
Yeah, against non-state officials. Apparently the position is that you can bring it against WEC complaints against non-state officials, but not the WEC officials.
So what we're trying to discern is, what can your client not do that it could do before?
Because of the Wisconsin Election Commission denials of hearings and final determinations, the Wisconsin Election Commission cannot have the hearings and the final determinations that Congress guaranteed it. It's a concrete right. Congress has the power to define a private right and remedy, and when it's deprived, that's an injury. Now, that injury has many consequences for the Wisconsin Voter Alliance, which we mentioned.
What are those consequences?
Well, if you win, then maybe things get fixed. Maybe it leads to other projects. If you lose, maybe it leads to other projects like lobbying Congress. The whole purpose of the congressional scheme was to have the state election officials put on their evidence, 52 cards on the table, and have the matters administratively adjudicated so that the election process would be improved.
If Wisconsin Voters Alliance won by some other means, would that not be good enough for Wisconsin Voters Alliance? So if they took the same HAVA complaint that WC did not want to adjudicate for ethical reasons, and then they won through this other procedure or alternative that you say it's not a good enough alternative. It's an alternative, but it's not good enough for WVA. But if they won And therefore, they got a ruling that WEC violated HAVA in such and such way. And therefore, WEC had to change its procedures or, do something to improve the situation as a result of that ruling, whether it came through the circuit court or the district attorney or some other state administrative authority, but not WEC. Would that not help WVA to achieve its concrete goals that you're discussing?
Yeah, there aren't any alternatives, but I wanted to work for WVA in that sense. We went through that in the
You
brief.
say there are other alternatives?
There are not. Those alternatives don't work. But when Congress guarantees a private, private right to a hearing and to a final determination, and guarantees a remedy, that is the state adjudicating the HAVA complaint, that's guaranteed. And the federal courts are to interpret congressional enactments when it's on the face, shows a private right, private remedy, it's unambiguous, a binding obligation on the state, is to interpret them, fairly. And
Let's talk about a third type of standing, this imminent tangible harm. In Hewer's declaration in the gray brief, it states, Hewer says, I believe that neither of the two paths the WEC suggested to be applicable. That would be referring to your complaint in the county or to the state court. Does that mean that the appellants here are not planning to pursue any of those alternative pathways? Is that correct?
The appellants are waiting to resolve this 1983 complaint to see what pathway to take. This is the most efficient pathway for them for the reasons I've stated. It's cheaper, it's faster, it's better. And that's why Congress created it.
Would your clients will not incur any costs or face any injuries from trying to pursue those pathways, will it?
Absolutely. A violation of the right we're talking about here. When Congress creates...
Okay, but the clients are not claiming any actual or imminent financial injuries, correct?
No, it's an intangible harm. And the intangible harm is that Congress created a private right to file a HAVA administrative complaint, and the complainant has a right to a hearing,
You
and a
made
right
that
to
point.
information.
I understand that.
So that imminence involves, okay, we have additional HAVA complaints we want to file against the Wisconsin Election Commission. We want to use this cheaper, more effective, faster procedure. We have a 2022 denial, we have a 2023 denial, and then the government, Wisconsin Election Commission, is fighting vigorously. This is a vigorous defense. This is a very expensive litigation over whether they're going to have hearings and final determinations on black HAVA complaints.
My question goes to imminent financial injuries. Your clients are not saying that there are imminent financial injuries as a result of the determination here, correct?
Of course, it affects fundraising. These HAVA complaints are winning complaints, and we can't get them adjudicated. That's how the business works. You go out and you tell the donors, we're a high return on investment 501c3. We're going to get results. If you get results, you get more donations. It's like type of a business. It's just like a business.
So it would interfere with fundraising. Anything else that you're offering?
Well, the expense, well, I went over in the brief, but the expenses and so forth. But the big thing is the denial of the access to the private right and the private remedy, and that's what Congress intended. I'll reserve the time.
We'll be giving you some rebuttal time, Judge Jackson.
Yeah, thank you. Do you have a case that supports you on this? You say Congress has specified this right. This is the right. It shall be produced this way. Do you have a case that supports you there that does not take us into the other cases like Knight and Smith that are teaching us that people are not there to have the right to petition for their government, but not a specific response?
Yeah, in my view, this is fairly pedestrian with respect to the federal courts when Congress enacts a law that allows for citizens to petition for redress of grievances and codifies it, like in the Federal Tort Claims Act, the Tucker Act, Freedom of Information Act, Section 1983, Driver Price Protection Act, all those cases. All those cases under those laws, the courts have hearings and adjudicate the claims. So it's no different when the Help America Vote Act, or Congress, pursuant to the Election Clause, instructs the states when you're doing these federal elections in your states, you must provide this HAVA administrative complaint procedure as the mechanism of enforcement against the states.
Thank you, Mr. Cardall. We will be giving you some rebuttal time. Mr. Kosky, let's move to you.
Good morning, excuse me. Good morning, may it please the court. I have two main points today. Both relate to standing. The first is that the district court correctly held that there was no concrete injury when the plaintiffs alleged a bare procedural violation of HAVA. Judge Kirsch, I heard you in prior arguments say, what's your best case? Our best cases are Spokio, TransUnion, and Alliance for Hippocratic Medicine on standing. We believe that Spokio and TransUnion resolve the concrete injury part of the standing analysis. Those are our best cases. My second point on standing is that the claims are not redressable. The district court didn't get to this one because it didn't need to, but nonetheless, HAVA provides that HAVA claims on the merits are resolved by state tribunals, not federal courts. So when the plaintiffs were dissatisfied with how the Elections Commission disposed of their HAVA complaints, the proper place to go was through a state court judicial review. That was the procedure that was available. That was highlighted for them in the two letters they received. They, in fact, referenced Chapter 227, which is what we've highlighted in our briefs. They could have sought judicial review of the determinations that there were conflicts. And a state court judge could have determined under state law whether there were actually conflicts that prevented the commission from resolving these HAVA complaints.
How often do people bring HAVA complaints against the WEC itself?
Not infrequently, it does happen.
Because, you get the sense, or, WVA would not be crazy if it got the sense from the letter that WEC was kind of making it up as it goes along and trying to give them a viable alternative. Shouldn't WEC ought to have a standard process for when they receive these complaints, they're asking WEC to judge itself?
Sure, and the letter actually has become standardized. So the letter they received, similar letters are going out now when there are complaints filed against.
So were theirs among the first, 22, 23, 19, 2022, 23?
I'm not sure it would be fair to say theirs were among the first, but these types of complaints against the agency have become more common, I'd say, in the last 5 years. HAVA has been around since 2002. So I think it's sort of a newer phenomenon to be doing this in the last 5 years or so. We didn't talk about, or the district judge didn't address the merits of the cause of action issue. But where I started in my brief was that there's this intractable conflict that the agency has. And I raised the Caperton case because I think it highlights that you can't be the judge of your own claims against you.
And Teagan says it too, although is that dicta?
It is not dicta, but it is not a majority opinion. That quote is not from a majority opinion. I believe it's Justice Hagedorn's writing. But anyway, that Teagan decision did illustrate the same principle. And another court has said that the commission can't be the judge of claims against it. So with regard to the concreteness issue, I think the focus here has to be on the declarations and what do the declarations actually say about the core objectives of the Wisconsin Voter Alliance and these individual members. And our position is that the declarations, since we're at summary judgment, do not establish a concrete injury. So what they talk about are things that Mr. Hewer and Mr. Brown and WVA could do even if they don't get a decision on their HAVA complaints. So they can still engage in the issue advocacy that they want to. They can still go before the legislature and lodge these complaints. They can even lodge the complaints about the Elections Commission with the legislature. And there's nothing stopping them from doing that when they don't have decisions on these HAVA complaints. Now, I think that it would be, it could cut both ways for them. They get a decision that's favorable, they can wave it around and say, look, this is a problem. There's a problem here under HAVA. If they get a decision that's negative, that could be negative for them. So I think that it can impact them, but it doesn't stop their core activities that they have highlighted in their own declarations in this case. So on that first part of the analysis on concreteness, we think they lose. On redressability, they also lose because HAVA is very clear. It is an unusual statute and that it is setting up a procedure where only state tribunals can determine federal law. It's very strange. So here, there is no other place to go. There is, as we argued and the district judge highlighted at the very end of his decision, what might be proper is that if an agency is receiving HAVA funds, an audit of that agency is the right remedy. And maybe that's what plaintiffs should be asking for. So, but under no circumstances, HAVA provide that you can go to federal court to address those claims. Now, this touches on what the district court called the cause of action part of this case. And the district court didn't address that, but I want to address it because opposing counsel did address it in his reply, and I want to get a chance. So this court has never addressed whether Section 1983 can be used to raise a HAVA claim. Other circuits that we've highlighted in our brief, the 11th, the 5th, 6th, have said that that is a no-go. So you cannot use Section 1983 to raise a HAVA claim. And then it's almost universal in the authorities that are cited that HAVA itself cannot create a private cause of action in federal court. So those are...
You've been with this argument and this whole discussion conflating Article 3 with redressability understanding, Article 3 redressability.
I don't think so. I think it...
With whether a party has a cause of action.
I don't...
Different questions.
I think there are two different questions, Judge Jackson-Akumi, but at the same time, in the standing analysis of redressability, it has to be considered whether there is a possibility of awarding a remedy. And under this specific scheme, there isn't. So it's very unique statutory scheme that Congress has set up here. I could not think of another good example of something like this. So in any event, we think that under either of those prongs of standing, this fails. And then if the court wanted to get beyond standing and go into the cause of action question, the plaintiffs also lose. And we briefed that all below. If you want to see where that is, in our motion to dismiss brief, which is docket entry 8 at pages 26 through 29, we laid out all the authorities for this issue as well. And again, I only bring it up now because in the reply brief, it was raised for the first time. Really, my focus today is standing, and I want to answer any questions the court has about that issue. Again,
on organizational standing, Hippocratic Alliance has cut back Havens Realty. Do you think that has ramifications for any of our case law?
I think it definitely could. I mean, I think, first of all, Hippocratic medicine is directly relevant here because one of the claims in Mr. Brown's declaration is that there was diversion of resources. Hippocratic medicine has said that is not allowed as a basis for standing anymore. So that's gone. I'm not aware of specific Seventh Circuit cases that would be undercut by Hippocratic medicine, but in any event, we believe that the district judge was correct in applying that case.
What are the circumstances in which an organization could have standing in its own right after Hippocratic Alliance?
Well, I think that if they could show one of the intangible harms that Spokio or TransUnion actually discussed. So for example, they talk about the tangible harms are monetary or property related. If they could show harms like, I think one of them is harm to reputation is one of the ones that Spokio talks about. So if they could show some of the intangible harms that Spokio and TransUnion actually laid out, that would be a good example.
When Mr. Cardall, excuse me if I mispronounce it, says we can't get donations because we don't have a WC decision on our HAVA complaint. Why would that not fall into that lane?
I think that falls into the Hippocratic medicine case is directly controlled by that. That specifically said that if an organization is claiming that it's spending funds to advocate against something.
See, that's not spending.
Well,
that's him saying we can't get donations because we're not producing the results we promised supporters and would-be supporters. That's not for spending.
Judge, I think this is kind of hypothetical. I don't think it actually alleges that in their declarations. So I don't recall it actually alleging that. And if it did, that would be a different issue. So I think that, number one, my position is Hippocratic medicine does address that claim about funds diversion and loss of opportunity for use of funds. But and the second part of it is that's not part of this case. They don't make those allegations. They only talk about diverting funds in their declarations. And again, we're on summary judgment. We have to focus on what's actually in the record. With regard, I want to segue into the First Amendment claim because the court has already picked up on it, the redress of grievances claim. As we've shown in our briefing, the Knight case, Smith, the operating engineers case, the 2020 case from this court, the Hilton case, all of those cases do not support their First Amendment theory. So they had two constitutional theories. One was due process. The other was First Amendment redress of grievances. They, in their opening brief in footnote 2, say, nope, we can't do the due process claim. We acknowledge that. So they have not pursued that further. They're still pursuing the First Amendment redress of grievances claim, but as we pointed out, that one is again, a no-go. That doesn't go anywhere. They can still petition for redress of grievances, and if they get responses they don't like, that doesn't offend the First Amendment. So we believe that that is not a viable intangible harm claim that can create the standing they need for the concreteness injury, for the concreteness part of the standing inquiry. That just is not going to do it. I think I've addressed what I want to today about standing it. So I want to give the court a chance to answer any questions. Otherwise, I will cede back the remainder of my time.
Nothing further. Thank you, Mr. Costa.
Thank you, Your Honors.
Thank you. We'll move now, Mr. Cardall, back to you for 2 minutes of rebuttal.
As it goes, the determination of harm is determined by Congress. So Congress determined the harm was the state officials at WEC violating HAVA. They create a private right for a person to go into an administrative tribunal and to make a complaint saying that that harm is occurring. And the remedy is to order to stop the harm from occurring.
And the harm is?
The violation of HAVA.
Yes. All of these various standing doctrines are asking for something that would explicate or explain what that harm is to your clients. And this is your opportunity, Mr. Cardall, to tell us how WVA and Brown and Hewer were harmed.
Right.
We talked a little bit about fundraising.
So Congress gets to decide the harm that's regulating. Congress said violating HAVA is harm. The citizen can make a complaint, have a hearing, and adjudicate that harm. Congress gets to do that. Nothing we do on the standing doctrine can take away Congress's decision that there's a right to sue, there's a right to a hearing, there's a right to a remedy to address that harm. And the harm is the Wisconsin Election Commission officials violating violating HAVA. So that's the HAVA. This is the statutory mechanism for enforcing HAVA. And here the Wisconsin Election Commission is saying we're not going to follow that law. But the court, the federal court, has to follow the law. And the court has to find a way to give life to the statutory mechanism provided to enforce HAVA against the Wisconsin Election Commission officials. And the way to give life to it is to apply Spokios I talked about and see that there's a private right to sue, bring an administrative complaint to get the hearing. There's a remedy, the adjudication. And what Congress is addressing was the harm of the Wisconsin Election Commission doing that. Can I make one last note?
Okay.
Based on the Wisconsin Election Commission arguments, the state law binds them from adjudicating the complaints against the state election officials. It appears the state laws violates HAVA. So it's not, they're saying it's not their policy. It's the state statute that says we can't adjudicate administrative complaints against state election officials. Nothing could be more horribly contradictory to the Help America Vote Act provision for administrative complaint procedures than Wisconsin Election Commission's argument today. Thank you.
Thank you, Mr. Cardall. Thank you, Mr. Koski. The case will be taken under advisement. Our next case is being submitted on the briefs, so we're going to move to Appeal 25-1013. This is NT and PT versus Gailsburg Community Unit School District. And we're going to begin with oral argument. from the appellant. Ms. Satterley, you may approach. Thank you very much.
Good morning, and may it please the court. My name is Fraser Satterley, and my firm represents the appellant, the Board of Education of Gailsburg CUSD number 205. Your Honors, the issue before you today is relatively simple, but of great importance to educators throughout this circuit. When it comes to disruptive behaviors in the classroom, where is the least restrictive environment, or LRE, line drawn when those behaviors impede both the student's and his classmates' ability to access their education?
What's the status of the placement right now?
He's currently in a stay put placement under IDEA, which means he is, the student is remaining at Silas Willard.
So that's where he is right now. There's been no movement. This has been, what, 2 years almost that this the administrative proceeding began?
That's correct. So stay put was triggered upon the parents filing a due process. That hearing occurred over March and April.
So the student was in first grade?
That's correct.
And now the student's in third grade?
Correct.
And it's still the district's desire to move the student to a different school?
That's correct, Your Honor. That has not changed.
What's the standard of review that we should apply in considering the district court's work here?
Well, I think there are two, Your Honor. The first, we've raised three separate bases for appeal. One, that the trial court engaged in an improper trial de novo, and the other, that it misapplied this court's holding Beth B, and that is that of its progeny, and that it ignored the prohibition enunciated by our Supreme Court in Rowley and Andrew F, that trial courts are not supposed to substitute their notions of sound educational policy for those of the school authorities, which they review and have the day-to-day access to the children. So in terms of the standard of review, it is de novo on a mixed question of law and fact with respect to the application of Beth B and the question of whether or not he could receive a free and appropriate public education in the least restrictive environment. The standard of review for considering whether the trial court inappropriately considered or failed to consider the administrative record and conducted a trial de novo is clear error.
Okay, but I want to push you on that a little bit because I'm not sure that that's right.
Okay.
When we're considering whether or not the district court gave due weight to the administrative hearing officer, why is the standard of review not de novo? Why is that not a question of law? Or at least a mixed question of fact and law? Other circuits have found that very clearly, that we don't, we as judges are, how should I say this? We are not educators. We are not in a position to determine what is in the best interests of children. We're just not. That's not what we're trained to do. When I read the administrative law or the independent hearing officer's argument or position in this case, she thoroughly discusses the 1-to-1 ratio.
Correct.
Then the district court, in a very short opinion, says that she didn't do it properly.
That's correct.
Rejects it and finds that they should try a 1-to-1 ratio. I don't know what she didn't do properly, and the district judge doesn't tell us.
I agree that it's unclear on the record, Your Honor.
Why should we review that for clear error instead of de novo? In other words, why should we not look at whether or not the district judge afforded due weight to the independent hearing officer under the de novo standard of review?
Well, I will say if Your Honor is inclined to apply the de novo standard of review, the school district is certainly willing to accept that review of the law. But in terms of the deference, I think the issue here, we're talking about that sliding scale of due deference. And the case law from this circuit is very clear that obviously the trial court had the ability and the discretion to take additional evidence.
And the state really didn't oppose that, by the way.
I'm sorry?
The state really didn't oppose that, which is fine. I mean, the state objected to one witness, fine, but other than that...
Because I think both parties had an interest in this case in supplementing the record.
And so does the district judge. I mean, I don't see the trial de novo as a problem.
Correct. I think the issue here is with that due deference scale, while he could provide less deference to the hearing officer as he took on more evidence, none of the case law enunciated by this circuit indicates that that level of deference should be 0.
And if we find that the district judge did not afford due deference to the independent hearing officer's determinations, what do we do? Do we remand for the district court to take another look at the independent hearing officer's determination, consider additional evidence at this point? The problem with these circumstances is a child is developing every day.
Correct.
Things change every day. Between first and third grade, that's a big difference.
It is.
For you and I, 2 years is hopefully not that big of a difference, but for a first grader, it's a big deal.
It is. So I want to make sure I'm properly addressing.
If we find that the district court did not afford due deference to the independent hearing officer's determination, what do we do?
I believe this court can, it's certainly within your purview to reverse the district court and reinstate the findings, the final determination and findings of the hearing.
Aren't we weighing evidence? We didn't see the witnesses testify. We can't judge their credibility, determine their demeanors.
No, Your Honor, I don't believe you're weighing evidence. I believe you're reviewing the district court's lack of deference to the hearing officer.
We're reviewing that as a matter of law.
Yes.
And we find that the district court did not appropriately defer to the independent hearing officer. Don't we have to give the district court the opportunity to reevaluate the independent hearing officer's determination in light of the evidence that the district court has already taken and maybe will take more?
I don't believe it would be appropriate for the district court to take more evidence at this point, and I don't think that it's absolutely necessary that this court remands. I think some additional evidence was adduced for the very limited time period from August of 2024 to October of 2024. And the issue is whether or not, instead of supplementing the record, the judge supplanted the administrative record with that information. And I think this court is able to review that and without remanding it back to the district court.
Let me ask you this. Why wouldn't the reasons that the parties did not object to the district court taking additional evidence in 2023, 2024?
Yes.
Why would they not apply even now with the passage of time? So they are about 6 months that pass.
Sure.
Right?
Sure.
Between the administrative findings and the district court's trial.
Correct.
Okay. Now, as we've been discussing with Judge Kirsch, 2 more years have passed.
Correct.
Why wouldn't the same reasons leading to taking additional evidence in that 6 month period not apply to this 2-year period?
Are you asking if you remand why it wouldn't be appropriate for the court to consider even more evidence?
Yeah, because you were very clear that you did not think that would be appropriate.
Well, I think from a practical perspective, Your Honor, that would lead to these cases never ending. I think that there has to be an end point, right? And if we do it that way, I think we're running into a particularly slippery slope of, well, the child is not static, to Judge Kirsch's point. But there has to come a time when the hearing officer's findings and facts of conclusions of law at that specific time are given that deference. So I suppose if you did remand it back and with directions for the district court to hear more evidence, at some point, and I want to be clear, this child remains in his stay put placement pursuant to that order. And there are still issues, and they have to be addressed. And what is the school district to do? So I think the issue there is how much time is going to be afforded and how much additional evidence actually has to be made before a decision is made with respect to this child's education.
Would you like to reserve the remainder of your time for rebuttal?
Yes, 1 minute, Your Honor.
Very good. Thank you, Ms. Savory.
Thank you.
Mr. Wysong, we'll move to you for argument on behalf of the appellee.
May it please the court, Charlie Wysong for the appellee CT and his parents, NT and PT, social worker and a former board member who are here from Gailsburg this morning. This case is about whether the school district violated the mainstreaming requirement of the IDA when it chose to send a 7-year-old with ADHD an hour away to Peoria to a fully segregated school after just 3 weeks. And this record has no dispute over evidentiary rulings. There's no dispute of the controlling settled law that has been the law of this circuit since Ross 20 years ago and Alex R 20 years ago as to the standards. There's no dispute over the scope of the record. The judge found, following a trial, hearing witnesses in court, that the statute has been violated, and that ruling should be upheld. unless it was clear error. And it was not clear error where the judge heard that CT is in a small, specialized program where children just like him, where CT is...
Can I ask you a question regarding the independent hearing officer's conclusion? I'm looking at the district court's opinion on your appendix A13, and the district court says, as the parents correctly point out, both the district and the administrative hearing officer did not properly consider whether additional reasonable measures would have made CT's education at Silas Willard Elements, classroom, etc. Where in the district court's opinion should I look for the district court's explanation to us as to why the administrative hearing officer did not properly consider whether additional reasonable measures? Because this just seems to me like a conclusion of the district court saying, I disagree with the independent hearing officer. And that's it.
The court actually explains and discusses the issue of the one-on-one aid and the testimony before it and the parties throughout.
But where specifically does the district court say, here is how the independent hearing officer did not properly consider the one-to-one? I mean, the hearing officer goes on for pages on the one-to-one ratio. The district court does it in a paragraph.
This court does not do it in a paragraph, Your Honor. If you look through the recitation of the evidence and the testimony, and in particular, the district court was explicit, and the record is undisputed, that there was new evidence here of changed circumstances. The judge below found extensive changed circumstances.
Where specifically as to the one-to-one ratio? I'm looking at pages A13 and A14. Where else should I look in the district court's opinion? 13 or 14 page order here.
Yes, Your Honor. The judge reviews the evidence throughout in A through A5, through A6, through A7, of all the evidence before it, not only of the need for the one-to-one, but of the changed circumstances, the new medication, the changes in staff, the new evidence that the administrative hearing officer did not have.
And what does that have to do with the one-to-one ratio? I mean, the hearing officer is saying, look, the testimony in the case does not support that a one-to-one ratio would further the interests of the child here for the following reasons, and then explains exactly why she rejects the one-to-one ratio. The district court engages with none of those findings, none.
The district court explains its reasoning as to the one-on-one aid.
Where?
At length, talking about how...
Where specifically?
Talks about Dr. Drew Leathers and T.E. Tasha Eastley, the review of the testimony that the hearing officer, that the district court heard. And the judge was correct that the hearing officer was mistaken. The hearing officer said that it was not possible to do anything more at Silas Willard Elementary. And that is undisputedly an erroneous factual conclusion, because the district witnesses have repeatedly admitted that they could have provided a one-on-one aid and that they provide the one-on-one aid for other students, and they did not do so in this case. The hearing officer was also wrong to say that the district had discretion under Latchman to choose among appropriate placements. That is a legal error, directly contrary to the least.
I'm going to push you on this. On page A34 of the appendix, the hearing officer describes exactly why a one-to-one aid. She writes, the testimony presented at hearing was overwhelming and uncontroverted on this point. This is the one-to-one aid. And then she goes at length to explain why a one-to-one aid would not help the child here. Where does I only see on page the district court saying, the hearing officer did not properly consider whether additional reasonable measures would have made CT's education satisfactory. But what about her analysis was improper?
Her analysis was not proper, and
because the district judge disagreed with it.
Because on a preponderance of the evidence and the judge's independent decision, which Congress has said is the standard to be applied here, that goes back to Rowley from the United States Supreme Court, the judge explains, if you go back to page 12 and into page 13, the specific reasons why the one-to-one aid would help CT. The reasoning about the description from the PhD occupational therapist Drew Leathers, who observed the child the week before the hearing, and the basic things that were not being done, the lack of attention to CT without the one-on-one at the time of the hearing in front of the trial court. This job of the judge under the statutory standard is to take additional evidence, as Rowley has said, and as this court has said in Ross, to make a, quote, independent decision whether the statute was violated. The judge did so, and as long as that conclusion was not clear error, it should be affirmed by this court. Again, these are not novel standards. The school district explains the standard the same way. The judge explains the standard the same way. We explain the standard the same way.
It's not a question of the standard. It's a question of the judge's engagement with the facts to proffer appropriate rationale for our review. So clear error doesn't mean get out of jail free. It means we've got to be able to see enough reasoning in the record. That's the tenor of the question.
Understood. And if you read the judge's opinion as a whole, whether it said line by line, the hearing officer here and there, the judge explains his reasoning. And if the judge's reasoning is reasonable, it is to be upheld. That's what this court said in Ross. It said that on an IDEA case, the appellate court cannot independently determine what is appropriate for the child. It is only reviewing for clear error. And these are fact issues. This is why we have a trial. This is why we have the parents expert was there, the school officials were there. The judge heard from these witnesses live, up to the date, with new information that the hearing officer did not have. And the judge is clear in this opinion that he's relying on the new information. That is abundantly clear. He goes on at length about the changes in medication and the stability that was needed based on his provider and the testimony from the people who were observing CT as of the fall 2024. And that is the explanation of why he came to a different conclusion than the hearing officer. It's explained at length factually, and that is a factual conclusion entitled to clear error review by this court, and the conclusion was reasonable. It was reasonable where there was no dispute that CT did not have the one-on-one aid and that there was testimony that it would help. Right? This is what trial judges do, is make a credibility determination between witnesses who say the one-on-one aid would help and witnesses who do not. And it was not clear error to so conclude on this record. Among the other testimony was that CT had changes in medication between the administrative hearing officer's decision and the trial court's decision. The court heard testimony about the stability and progress on behavior. The court heard that CT is already learning. He was learning math, he was learning reading, he was hitting his behavior benchmarks. That was all information that the hearing officer did not have available. And at this point, at the hearing, the judge below did have that information available and came to the reasonable and correct conclusion that the statute had been violated. This is not a judge with hubris, Your Honor. If you look at the remedy here, it's very specific. There was a dispute over placement, and the judge says the IDA requires CT to stay at Silas. There's a dispute over the one-on-one aid, and the judge resolved that dispute.
Does CT require the one-on-one aid only because of behavioral issues or for other reasons as well?
The one-on-one aid is to implement primarily the behavioral and self-regulation strategies to allow CT to learn. So the one-on-one aid would be providing, facilitating the learning process, right? When he's getting frustrated and taking breaks. CT has a lot of academic talent, both in math and reading, as everyone acknowledges. And so primarily he's in special education for behavioral and self-regulation, and the one-on-one aid would be fulfilling the strategies that the school has identified for that purpose. I would also like to comment on the posture following this proceeding. Certainly the court has discretion to remand if it thinks appropriate. I do want to emphasize that by statute, this school team will be reevaluating CT at least once a year, no matter what. And so balanced with the interest in making a sound decision on a reasonable record, there does need to be finality. And whatever happens at the end of this case, whether it goes back or it gets appealed again, or whenever it eventually ends, throughout that process and after it ends, the school and the CT will continue to have to discuss, again next year, what is appropriate. And so this judge made a call on the record before it, and it was a reasonable call that should be affirmed.
Does the school only make that determination once a year at the beginning of the school year? Is that the way it works?
So the IDA that by statute requires an IEPT meeting, which is the school and the parents, the clinicians, and whoever else should be involved, meet at least once a year, can meet more often than that, to review the individual education program, right? What special ed is going to be provided. It's a 12-month requirement, so sometimes it's in December and sometimes it's in May, but that's a minimum that every year, no matter what, you have to have that meeting.
And that's continuing despite the litigation, right? They continue to do it. The school has just decided to stand by its recommendation, and the parents want the child to stay at Silas. as of now. That may change, right? I mean, okay.
At the end of third grade, there will be a meeting. At the end of fourth grade, there will be a meeting. And
I just want to make sure it's not static because of the ongoing litigation.
But
I know there's the stay put order. I understand that.
Yes.
But that doesn't mean that the two sides are not trying to figure out what's in the best interest of the child in the interim period.
Correct. The parties do continue to have that meeting, the AIP meeting, and have those discussions. At the same time, until this case and all appeals are completely done by statute, the placement does not change, right, except by agreement.
Thank you, Mr. Wysong. Ms. Satterley, we'll move back to you now for rebuttal.
Thank you, Your Honor. I only reserved a minute, so I understand that I don't have much time, so I'll try to be brief. I think counsel raised this issue, and I think this is important, that the judge here considered only the new evidence that was presented at trial, and that is really the crux of the issue, because in doing so, he ignored wholesale the entire administrative record. And the court's tunnel vision with respect to the assignment of a one-to-one aid, which, by the way, the statute does not require that a school district exhaust every potential intervention in order to, before it can recommend a change of placement. It's problematic. He also failed to engage with the considerable evidence regarding this student's behaviors, of which there are many. And there's a data from the time that he started kindergarten in the fall of 2022 until now. And with respect to the one-to-one aid, this student has never been without the support of an adult. In fact, he's in a classroom where the student to teacher ratio is 7-3. So this idea that perhaps we didn't give him in the IEP document itself a specific one-to-one, but in practically, he was receiving that kind of embedded therapeutic support from adults on a daily basis. So, at the end of the day, I think you come back to the question that was posed by this court in ZS, and I think that you look at this circuit's precedent in the District 211 versus Ross case, and you have to look at the behaviors when we were talking about a change of placement with respect to the least restrictive environment. And the question that was posed there was, what could a full-time teacher's aide in the ZS case, what could even a full-time teacher, I'm sorry, I'm out of time. May I continue just to finish my thought?
Just final thought.
Thank you. In ZS, the court had very aptly stated, and I think this applies with equal force here, what could even a full-time teacher's aide have done to restrain this wild child when he started kicking and biting people, tearing his clothes, breaking furniture, and otherwise acting out as he had been doing for years with no improvement. And those types of behaviors are the same types of behaviors we're seeing from this particular student.
Thank you, Ms. Satterley. Thank you, Mr. Wysong. The case will be taken under advisement. We'll move now to our final appeal of the morning. This is 24-1822, United States versus Duncan. And we're going to begin with oral argument on behalf of the appellant, Ms. Lee.
Thank you, Your Honor. Good morning, and may it please the court. My name is Lauren Lee on behalf of appellant Thomas Duncan. We respectfully request that this court vacate Mr. Duncan's sentence and remand for resentencing for two independent reasons. First, the lower court erred in applying the multiple bribes enhancement. And second, it erred in attributing all of the pattern purchases to Mr. Duncan in the absence of sufficient evidence by the government. Both errors resulted in a 4 offense level enhancement, which if vacated would reduce the advisory range by at least 30 months. Because errors in the guidelines calculations are presumptively prejudicial and the sentencing court's inoculating statements were insufficient, these errors are not harmless. I'll address these in turn, but I'd like to begin with the loss amount. The sentencing court applied a 16-level enhancement, concluding that the loss amount attributable to Mr. Duncan was greater than $1.5 million. This is clearly erroneous because the government failed to present any evidence that the pattern purchases that were not directly attributable to Mr. Duncan, according to the purchasing data, were reasonably foreseeable. The amount at issue here is $370,000. And that amount is enough to reduce the loss amount enhancement by 2 levels.
What's your theory on who could have instigated the pattern purchases, if not Mr. Duncan? I do note that it was Dingle who approached Duncan. So I'm not clear, are you suggesting that Dingle could have approached other, kind of unapprehended suspects and have the same kind of deal going with them as he did with Duncan? Or is there any reasonable explanation for someone else other than Duncan putting in those pattern orders above and beyond the $800,000?
Thank you, Your Honor. And that's definitely a possibility, but the problem here is that it's the government's burden to prove what could have happened here, and they have failed to do that. The $370,000.
What's their burden? How do they prove it by what?
To prove the loss amount.
By what standard?
By a preponderance of the evidence, Your Honor.
Okay, and they can extrapolate, right? It happens all the time in lost cases.
Correct.
Okay.
The $370,000 is the difference between the total amount of pattern purchases, which was just over $1.7 million, and the VA's purchasing data that referenced Mr. Duncan according to the government, which was just over $1.3 million. Other than the fact that these are pattern purchases, the government has not presented any evidence linking this $370,000 to Mr. Duncan. The government argued and the sentencing court agreed.
Why is the pattern evidence not enough? That's pretty strong evidence.
Sure, Your Honor. So the pattern purchases, and there was a lot of discussion during sentencing about that. The pattern purchases are the loss amount to the VA, but there's another step beyond that that's required at sentencing to determine which enhancement applies, and that's that the court must determine the amount of the loss that is attributable to each defendant. And that didn't happen here based on the evidence.
Were there other defendants that were engaging in pattern purposes?
We don't know the answer to that, again, because the government didn't prove that.
Well, no, the government never proves a negative. There were nobody else indicted. There were no other. You're not arguing that the losses were attributed, that there were others that participated in this bribery scheme to which the loss should have been attributed. You're just saying you don't know.
That's correct. You're
right.
We don't.
Yeah.
And that's something that the government could have investigated. I understand that no one can prove a negative, right? But ultimately, we could have a lot more information in the record here about what could and ultimately did happen.
Well, your client could have told you as well. I mean, there is that. I mean, I guess what I'm saying, I don't want to get into the various, but usually when there are multiple people that are involved in a scheme, a defendant will say, my client was responsible for X, but not Y. And that didn't happen here in the district court is what I'm saying. Nobody said that, right?
Right, and my response, Your Honor, would be that that's not the defense's burden.
I'm not saying that there's a defendant's burden at all, but the pattern evidence here is extraordinarily suspicious. And you're just saying that the government didn't prove that everybody else at the VA was innocent of engaging in pattern conduct, right?
Well, you should answer Judge Kearse's question. I have a follow-up question, though, because the language is the loss needs to be directly attributed to Mr. Duncan. So can you address that as you address Judge Kearse's question?
Yes, and I think I understand and I'm remembering your question. Forgive me if I'm not. And I think that this ultimately goes to what the government argued and what the sentencing court ultimately agreed with them about this issue. So on attribution specifically, the government pointed to the fact that Mr. Duncan sometimes directed his colleagues to place these orders. And the issue with that is that the ordering data does actually directly reflect when that happened. There was a comments field. We have over $500,000 in pattern purchases where the comments field says something along the lines of per Duncan, right? So the sentencing court, based on the government's argument, said, well, there's this universe of almost $400,000 in purchases that we don't know what's going on with, but we can assume that because we know that he was directing people to place these orders, that this also falls into that category. And there's not enough evidence to suggest that that's the case, especially when the purchasing data already accounts for that situation. And to your question, Your Honor, this court in Newton has explained that for conduct to be attributable to the defendant, that it must be reasonably foreseeable. The district court relied on speculation guised as an inference, but that does not satisfy the reasonable foreseeability standard. Proving reasonable foreseeability requires the government to establish a connection between these purchases and to Mr. Duncan, and they have not done so. For the remaining purchases to have been reasonably foreseeable to Mr. Duncan, the government needed to prove that they were directly connected to him or that he knew that someone else was placing these phantom orders for Dingle. Neither of those things have been shown. In the absence of evidence, the foreseeability question ultimately cannot be answered. And in this situation, all we're left with is speculation. We know from Newton that speculation is not enough, and this court in Newton vacated the appellant's sentence for that exact reason. Here, the government just didn't meet its burden. Therefore, this finding is clearly erroneous. Next, I'd like to address the multiple bribes enhancement.
Can I ask you one question before you get there?
Please.
Do you have a harmless error problem here? Because these things were litigated they were really litigated to death in the district court, and the district court was pretty clear that he would have given the same sentence even if he would have found the loss amount in your favor or your client's favor.
Your Honor, I'm happy to address harmless error next. So these errors were not harmless for two reasons. First, the errors in the guidelines calculations are presumptively prejudicial, and ultimately it's the government's burden to show that the sentence would have been the same absent these errors. And second, the sentencing court provided insufficient inoculating statements, which failed to provide a detailed explanation of the parallel result. We agree with the government about the language that the court used, but the issue is the sufficiency of that language. There's two passages in the transcripts that are at issue here. The first one is on April 10th on page 164. The second is on April 12th on page 43. This court explained in Ashbury that a sufficient inoculating statement should contain two things. First, a detailed acknowledgement of the contested guidelines issue, including the reduced offense level and the resulting advisory range. Here, the district court acknowledged that these two errors may have occurred, but ultimately nothing more. There was no acknowledgement that the offense level would have been reduced by 4. There was no acknowledgement that the resulting advisory range would have been reduced by at least 30 months. Second, the statement needs to include an explanation of the parallel.
Obvious?
Isn't that obvious? Is that your question?
Yeah, wasn't that obvious? I mean, you're saying the district court has to explicitly state that on the record as if the district judge didn't know that?
I mean, I think
there's a whole argument at sentencing. You've got the pre-sentence report. Everyone's got it. The judge asked 10 times, does everybody have it? He sets forth the guideline levels. You're arguing that it's a 2 or 4 level decrease. And now you're saying that the district judge has to repeat that to have a sufficient inoculating statement?
Your Honor, it's not just about repeating it. The purpose of this harmless error standard is for us to have confidence in the fact that the sentence would have been the same. And consideration of a properly calculated guidelines range is a requirement. It's not a formality, it's a requirement. And so if we don't know that the lower court, the district court, was actually considering what the result of these potential errors would be, we don't know whether or not he was actually considering whether the sentence would be the same or not.
Would you like to reserve the remainder of your time?
Yes, please. Thank you, Your Honor.
Thank you, Ms. Lee. We'll now move to oral argument on behalf of the appellee, Ms. Manshra.
May it please the court, Heidi Mantrek on behalf of the United States. The district court here did not clearly err either in finding that the scheme that the defendant was involved in involved more than $1.5 million worth of loss, and that full amount should be attributed to him. And the district court did not clearly err in finding that the scheme involved more than one bribe. I will start with the issue of the loss to pick up from where the appellant was arguing. Here, the pattern purchases were extremely suspicious, as Your Honor has noted. They involved quantities of these disposable blood pressure cuffs that were far in excess of any bona fide need of the VA. And they were initiated repeatedly by Mr. Duncan. Now, to be clear, the purchases were actually made by Mr. Duncan's subordinates. And so every time one of these orders was placed, it was initiated by one of those subordinates. The evidence of Mr. Duncan's involvement in each of those orders came from emails that were sent to those employees instructing them to place the orders, and from records within the VA's electronic purchasing system, as defense counsel just noted, in the comment column of the purchasing records saying Mr. Duncan had initiated the purchase. But importantly, each of those subordinates who initiated those purchases, they were interviewed by investigators, and the subordinates described how at times the instructions from Mr. Duncan would come to him verbally. And that was what the district court relied on in disagreeing with the defendant's position that only purchases for which there is one of those electronic records corroborating Mr. Duncan's involvement in the purchase should count. The district court disagreed with that because he explained it resonates with common sense that when those instructions are given verbally, there's not always going to be an electronic record of that instruction. And so the district court also noted that, as our honors have pointed out, there was only one bribe payer and bribe payee here. The government did investigate whether anyone else was involved, and found no evidence of another insider at the VA being involved in this bribe arrangement in exchange for these pattern purchases.
If this provision of the guidelines is incorporating bribery law by reference, should we incorporate the stream of benefits theory?
So to the more than one bribe point, I don't think there's any need to get into the stream of benefits theory on the more than one bribe issue, because just based on the text of the guideline itself, the conduct here meets the definition of being more than one bribe. Specifically, we have multiple payments in exchange for multiple official acts. And each of those exchanges of payments for official acts is a bribe. And that's a very common, clear understanding of what a bribe is. So a stream of benefits theory, it typically involves something closer to that retainer concept, the idea that I'm in your pocket, and I'm happy to sort of do anything on your behalf in the future, but we haven't yet determined what those acts are going to be. That's just not what happened here. What happened here, as the district court found, was that there was a lot of ad hoc negotiation of specific payments for specific orders over time. There wasn't some agreement on the front end and no further discussion. It was in fact, as heard on the reported calls from 2018, there was clear ad hoc negotiation of how much would be paid, how much would be involved in the order, which products would be involved in the order, all of which shows the negotiation of a single separate bribe on those calls.
Speaking of what other courts are doing, do you know what other circuits have adopted the Second Circuit's Arshad factors?
So the Arshad factors are certainly adopted by the Second Circuit itself. In addition, the Third Circuit, in an unpublished case, I believe it's Mariano, I believe references those Arshad factors. There's the Fourth Circuit in Harvey that also references those factors. To be clear, I'm not asking the court to adopt the Arshad test here. That test is kind of built around sort of three factors, the primary one being whether or not these payments are in exchange for distinct official actions. And I think that's where kind of the inquiry sort of ends here, because we have so many distinct official actions. We have literally hundreds of VA orders that were placed. So I think we meet the Arshad test, but I don't think the court has to adopt it in order to find that we have more than one bribe here. Unless there are any further questions from the panel, the government would ask that the district court's judgment be affirmed.
Thank you very much, Ms. Manschreck. Ms. Lee, we'll move back to you now for rebuttal. We'll give you 2 minutes for rebuttal.
Thank you, Your Honor. I appreciate it. I'd like to first respond to a couple of comments that the government made about the attribution issue on the loss amount. So first, the government is now saying that every time an order was placed that was by a subordinate. That's not true. There's nothing in the record that supports that fact. She also said that agreed with us that the verbal instructions are noted in the system. So as I was saying before, for the court to then say that, well, the orders that don't have that note are also are also attributable to him because common sense. I just don't think that that's enough here. And ultimately, the government could have very easily proven this by just asking these subordinates that were placing the orders, what was their habit? Were there times that Mr. Duncan asked you to place these orders and you didn't make the note? That would answer this question here. And ultimately, that fact is not in the record. I'd like to very briefly address the multiple bribes issue as well. This conduct is one bribe. There was one agreement between Mr. Duncan and Dingle in August of 2012 to initiate and approve orders for disposable blood pressure cuffs in exchange for kickbacks. This was the same payor and payee, the same beneficiary, the same product, and the same conduct or official action for the same benefit. That's one bribe. From the Supreme Court's opinion in Snyder, we know that a bribe is an agreement for future action. Absent that agreement, all you have is a gratuity, and there's been no debate about whether we are in the posture of having a bribe here versus a gratuity. We address the stream of benefits theory only to illustrate that the agreement can consist of a continuing course of conduct that results in multiple payments over time, but ultimately the number of official actions or the number of payments are not dispositive on that issue. Reading the stream of benefits cases together with Snyder, we understand that this type of agreement is one bribe. And the letter of the language of the enhancement itself also focuses on the number of bribes or unlawful agreements. For the reasons that we've discussed here today and in our briefs, the district court erred in applying this enhancement as well as the loss amount enhancement. We ask that this court vacate Mr. Duncan's sentence and remand for resentencing.
Thank you, Ms. Lee. Thank you, Mr. Kamener, as well. Thank you, Ms. Manshrek. The case will be taken to advisement, and we want to thank and recognize your firm for all the work that you've given here for purposes of this appointed position. So thank you.
It's been a privilege. Thank you, Your Honor.
You're welcome. The cases will all be taken to advisement, and that will complete our oral arguments for this morning.